So thank you, Pastor Frank. Appreciate you hosting us. Once again, we're talking about several issues, not only legal issues, but things that connect to legal issues, things that if they are not dealt with, if they are not handled, if they are not managed, become legal issues, okay? And so the key is to give you some practical things. You're penalized for what you don't know. Even the Bible says that we're destroyed for lack of knowledge. And so, sometimes when things go and they hit the fan and you end up having problems, a lot of times we like to say our fallback is, oh, I didn't know. Well, it doesn't matter if you didn't know necessarily. That means that you didn't mean to have what happened, but you're still dealing with consequences, okay? So, by the way, I'm looking in the right direction, right? Should I be looking towards that camera?
Yes, you can look at the camera.
Okay, perfect. Just making sure. So here's what I thought I would do. I thought I would just give you a couple recent developments related to CALIC, related to COVID. There's a bunch of stuff out there. One of the things that we'll do, we'll provide a resource. As we're going on, we'll edit it in. I'm going to include a few websites that talk about county to county, some local COVID things, some local COVID restrictions and that type of stuff. I'm going to give you a little information on a couple cases, Supreme Court, state cases, state laws, things that are going on related to mandates, because that seems to be where everybody kind of wants to talk about and is paying attention to, and is quite a moving target. And then I'm going to give you what I like to call tales from the lab. Talk about a couple kinds of cases we're dealing with and some things to maybe look for in that regard, okay? So help me here as I am using an iPad and I am a PC person. So, first of all, we're talking about the Supreme Court here, and hopefully this is showing up where people are able to see it as we're going through the on-demand product here. So let me talk about a couple cases that have come down to the Supreme Court lately. It was a big question as to whether and to what extent the Supreme Court would actually allow for the mandates that have been done by executive order by the president. Okay, so that's a big deal, right? And depending on who you are, people are on different sides of the issue. We should be able to mandate folks. We should be able to mandate this type of professional, but not that type of professional. Oh, I'm free and I feel free. I ought to be able to go to work, or I ought to be able to not have to wear a mask, or whatever the case, or not get vaccinated. That has split up families and people falling out at Thanksgiving and whatnot about vaccination. So, okay, so there's a couple key cases that came down in January, right about the same time with the Supreme Court. They did two things. So, and all of these are direct responses to executive orders that the president has issued, okay? So there was one executive order that was issued that required businesses over a certain type, private businesses over 100 people, I believe, to be either vaccinated or have a masking and testing policy. Okay, so that was one of the cases that was brought. Case was brought immediately, and even though, and this is one of the things that will often happen, even though the merits on these cases tried at some time down the road, most of the time when someone is trying to stop a practice, they'll ask for preliminary, relief, where you keep the practice that's being instituted that you want to protest from being instituted during the pendency of the litigation. So all of these litigations are still going on. All of these cases are still going on, but there were initial hearings to see whether or not the mandates would actually be stopped in the meantime. So as it pertains to the first case where the businesses over 100 people, private businesses, were required to be vaccinated or have a masking and testing policy, the Supreme Court blocked that. They blocked it 6-3. Probably went down conservative versus liberal lines. And so they blocked it, okay? And so therefore that, for the time being, even while it weaves through litigation, for the time being, that requirement, the larger businesses require employees to be vaccinated or to have a masking and testing policy, is undone. There's another case where there was a lawsuit because there was a Centers for Medicare and Medicaid Services vaccination mandate for healthcare workers. That's another thing that was issued by either executive order or by, directly from the president, or some kind of regulation that came on the executive side. There was a lawsuit related to that. The lawsuit is still pending, but in the meantime, can they be required to keep the vaccination in place? And the court actually said yes. And so therefore, for now, vaccination mandates for healthcare workers at federally funded healthcare facilities, that is still okay for now, okay? So it's still weaving through litigation and whatnot, but for now, the required vaccinations for healthcare workers at federally funded facilities survives. So the long and the short of it is the mandate for private businesses is squashed for now, and the mandate for healthcare workers in federally funded places, health facilities, survives. Okay, that's what we got for now. Okay, on that. Interestingly, for those of you that have flown and you've worn your mask, and hopefully you haven't gotten in a fight on the plane because people have a couple beers in the bar and they decide they want to be free and they don't want to wear their mask or what. Not to be insensitive to those of you that don't think you ought to wear your mask or have to get vaccinated, but it is kind of ridiculous when you're not the person flying the plane that you get in beef on the plane. But in any event, could have just drove wherever you were going. But in any event, the Supreme Court has rejected an emergency request to block a federal mask mandate for air travel. Actually, a father did it on behalf of himself and his young autistic child. Filed a lawsuit, wanted the mandate to be crushed on planes for now. The court has said no. So the Supreme Court, and in that case, not to get too technical, sometimes in a Supreme Court case, an emergency order is asked to be issued, and depending on where it is geographically, it will go to just one justice. And actually, this one went to Justice Neil Gorsuch. Neil Gorsuch rejected it, and he rejected it without comment or dissent. Okay? And this arises out of the president's executive order that requires passengers on airplanes and other public transportation to wear masks. Okay? So where we are right now is a general statement. Got to wear your mask on your airplane. Don't have to have a mask mandate if you are in a larger company, private company, but you do for healthcare workers at federally funded facilities. Okay, so that's where we are right now as it pertains to that. I could say more about it, but that's all I want to say for now, just to give you a sense for what's going on. But it's a moving target, and it's going to continue doing what it does. Let's talk a little bit about California. Here are a couple things that are coming up. These are some laws that have been proposed that are, I think, quite interesting. Okay, so California is leaning toward mandating more school-age students to be vaccinated. Okay, specifically, there has been introduction of a bill that would supersede Governor Gavin Newsom's student COVID-19 vaccine mandate by eliminating the personal belief exemption. So right now, even though there was a vaccination mandate for students at a certain age, there is a personal belief exemption. This bill would actually get rid of the personal belief exemption. Okay, and so actually what that would do is it would require all kids from kindergarten to 12th grade to get the shot by January 1st, 2023. That's what it would require, and only students with rare medical exceptions could opt out. So stay tuned on that. That's still going on. Here's another one that's going on. There's a bill coming up that would basically allow kids 12 and up to get vaccinated without parent consent or knowledge. Okay? Actually, I didn't know that myself, tell you the truth. And in fact, what it would allow is not just for COVID-19 vaccinations, it's actually for all vaccinations. And I didn't know that. And so it's interesting to look at. And this would go to all vaccinations, like we mentioned, including COVID-19, and it would be for minors ages 12 to 17. So stay tuned on that. California tends to lead the way on some of these types of things. California is going to most of the time err on the side toward vaccinations, towards mandates and things like that. So you have to continue to pay attention. what do you do if you don't like it? I don't know, because we're in a pandemic still, and people will feel how they feel about it. But you could always file your lawsuit and go from there. I think that there are agencies out there that are pro freedom or whatever else. There may be avenues that way, but it is very much a moving target. But without sliding into an exemption, I think people that go to school day to day are going to get closer and closer to being required to have mandates. Okay, so let's talk about a couple what I like to call tales from the lab. So I'm going to talk about a couple general issues that I've been dealing with lately, and then give you some advice on what we need from clients. Those are the attorneys in the room could absolutely say amen, because nobody messes up your situation. Like a client that's maybe a little less than truthful, or some of those types of things, or they decide to let you know what they think you ought to know, as opposed to letting you know everything that's potentially relevant. So let's talk a little bit about that. Been dealing a lot with discrimination and harassment. Okay. And as I may have mentioned before, there are several avenues for discrimination. I tend to deal with the state side, even though there's some federal things that we deal with as well. And so that usually looks a couple different ways for me. Sometimes I do Section 51 discrimination in the use of facilities and those types of things. I've had a couple lawsuits in that regard. But most of the time, I'm dealing with discrimination and harassment in the employment context. Under the Fair Employment and Housing Act, there are certain things that there are certain conditions of employment that should exist, and you should not be discriminated against, harassed, or retaliated against as someone in a protected classification. Protected classification can be everything from sex, gender, sexual orientation, ethnicity, just a lot of categories in that regard. So I've had a couple lately where I've had one on the harassment. There's a fair amount of sexual harassment out there still. Most of the time we see it in the context of the women being actually sexually harassed. But sometimes it could be men being sexually harassed. It could be people being harassed for any of a number of reasons. And so I had one recently where there was a younger person, somebody in their 20s, that was starting at a new job, and she was informed right away that the boss liked to do things a certain way. He actually didn't particularly care even to have employees that had kids or that were over a certain age and this kind of thing. And she found herself getting comments that weren't necessarily welcome. But what do you do when you're trying to keep your job and you have a family to support, and certain things are said and certain things are done, and some certain things are done on the clock that shouldn't be, and then ultimately you're sexually propositioned, and when you rebuff the sexual advances, you find yourself fired. Well, hello? That would be sexual harassment. Hello. Okay. All right. So I've dealt with that in that context. Often when you see harassment issues, they're going to be in the context of comments about sexuality, comments that are specific to gender, comments that would be unwelcome in the workplace. And here's something that, guys, listen, I really want to be sympathetic. Often when we talk about, pick a case, we talk about Bill Cosby or whatever else, often someone on the other side of the issue or one side of the issue is going to say, well, were these comments or were these things that happened welcome? Did somebody know that they were in this situation or whatever else? And I'm not coming down one side or the other on Bill Cosby, but what I am saying is that you have to be prepared for the notion that they're going to always look at the extent to which the things that were said and done were welcome. So if I am a person at a workplace and I allowed certain things to be said, even if you may have had your reasons for allowing them because you wanted to pick your battles or whatever else, that may potentially be a defense. So it's really important, if you can, to be as clear as you possibly can about a compliment not being welcome, about a hug not being welcome, about certain interactions with you and other people at the workplace not being welcome. It is important to be clear as a bell about that, because sometimes when things change midstream, you can take a compliment, not think of it as sexual or anything like that, and then the next thing you know, something progresses. You may feel a little pressure a certain way or whatever else, but it never gets any easier to cut something off. And so I'm not saying that to be insensitive to people that are potentially sexual harassed, but what I'm saying is there is always an evaluation of the context of something said, of something done, and that type of thing. So it's really important to have your boundaries and to be as crystal clear as you can possibly be, because depending on the situation, something that is done as to this particular group of people may be considered sexual harassment, and something done as to this particular group of people may not be considered sexual harassment. And that's why you really have to be careful about that. It's totally unfair. I agree entirely, but that's how it goes. Okay? So you have to be careful about that. I am seeing discrimination, harassment, and retaliation based on race, ethnicity, disability. Sometimes, people ask for their time off, or because they have an FMLA issue, they have to care for a family member, or because they have to care for themselves, they have to be off. They asked for a workers' comp form. They asked for a WC1 because they believe that they have a workplace-related injury, and those types of things. When you suffer an adverse consequence because you asked for something in that regard, or because you took time off work, which you had a right to do under the law, if you suffer an adverse consequence because of that, you actually may have a claim related to discrimination or retaliation for a medical condition, physical condition, those types of things. So your starting place should be, as things are occurring at your workplace, how and to what extent they are out of sorts. In other words, if you knew that you had 5 days of sick leave, if you knew you had 3 days of sick leave, and the boss started tripping on you once you got back from taking a day of sick leave, then that's a problem. Okay? Now, ideally, it's something, often you make withdrawals of goodwill based on goodwill being in the ground in the first place, based on plantings of goodwill. So if you're at a good workplace, if you work with people that are good, if your boss is good, they let you know where you stand, they're fair, they stuck with you, things like that. If you have a problem and you can have a discussion about it and get the discussion resolved, I will say on behalf of businesses that often businesses are, people that are big enough to have W-2 employees, but not big enough to have HR departments. Sometimes they have problems with the rules changing and them not knowing that the rules have changed. Okay? Now, should they know? Yes. Are they penalized for not knowing? Potentially so. But listen, if you're at a place that's good, where your boss is fair and those types of things, and there's a problem, if you can work it out, work it out. I'm telling you to go to court and do these other things as a last resort, not as a first resort. I am in court, and Jocelyn, who's going to be speaking later, is in court, and Kamala, who's going to be speaking later, is in court. And often we will tell you that going to court is not necessarily the first option, nor should it be. If you are in a relationship with someone, an employment relationship, a business relationship, or whatever else, and there's potential for the future to that relationship. I'm at my job today, there's a problem, I would still like to be at my job tomorrow. If you can treat the situation and resolve it as if you're contemplating a future with the other side, then maybe it can get resolved. Don't just run to sue people on technicalities. By the way, I don't like suing people on technicalities, okay? Because there need to be more good employers out here. And I told the story before of a guy who made an $80,000 mistake. I represented him. He was the employer. Basically, he knew he was large enough to have W-2s, not large enough to have HR. He knew that when it came to an alternative work schedule, there had to be a private ballot. He did not know he had to file the result with the state. So somebody comes along who he fired twice. That's the other thing. No good deed goes unpunished. So the lady that really shouldn't have been there at all, tell you the truth, keeping it real, she goes, gets a lawyer, gets technical, and hits him for $80,000. Okay? If that's you, listen, you got somebody out there, you're an employee, and your good boss has a technical violation, and all of you want to be on an alternative work schedule, but you upset, and now you want to sue them, don't call me. Now, if your boss is doing stuff that, what we would say back in Indiana with the family, stuff they know they don't got no business doing, that they don't have any business doing, things that they know they're not supposed to do. They know it's wrong. They told you things. I've got a client I'm representing now in a discrimination case where they told him that the boss called him boo and told him that he needed to go back where he came from and be with his own kind. Come on now. Now, you know better than that. Okay? So, if you got that case, call me, because we know that something in the milk isn't white. We know that there's a problem, and they know that there's a problem too. So I just say be careful about that. So discrimination and harassment. The other thing I'm going to mention real quickly is public policy. Often the same facts will lend to a public policy problem, even if it's not a discrimination problem. Discrimination can be hard to prove, by the way, BTW, without a smoking gun being called out of your name. I have some of those cases. But sometimes people think, they believe in their soul, morally, that this issue is a discrimination issue. And it might be. But if it's morally and it's in your brain, but the words haven't necessarily been said, it's hard to prove. However, though, if you have informed your boss of something that you reasonably believe to be against the law. I had this happen with a guy. Listen, tell you right now, employers, this is for you. Write this down. Never fire the HR director that knows what they're doing. Because by them doing their job, they're telling you about things that they reasonably believe to be against the law. And then you turn around and fire him for him telling you the truth. Had that happen. Great case, by the way. Great client. But he knew his stuff. He knew his stuff better than the other folks did. They bring in another person, change the job title for her, and she didn't know what she was doing. She got in there, proved it, that she didn't know what she was doing. They fired my guy, escorted him out with an armed guard just to embarrass him. And so by the time I came around to suing them and getting just a little bit down the road, they had already fired the lady who was the mistake, who shouldn't have been there. Okay? But public policy basically means that when someone has an adverse consequence against you because you've talked about something that you reasonably believe to be against the law, you don't even have to be right. Boss, isn't that against policy? People aren't supposed to take money and shift it over and keep it. It's not supposed to happen. Boss, isn't this a problem? We actually were supposed to write people up within 5 days, and you're writing somebody up 2 months after the fact, after you have an argument with them. Okay? If there is an adverse consequence for someone pointing that out, there's the potential for a public policy violation. And the thing that's important, and I think I've said this before, but this is why it really needs to be reiterated. Sometimes people think they have a discrimination case, and they might have a discrimination case in their heart, but it's hard to prove, but the same facts can give you public policy. Okay? And what's important about public policy and what has changed is the equalizer for employment cases is attorney's fees. Unless you get attorney's fees by contract, you and I are in business together, and we say as part of the contract, if someone has to sue someone else, the winner is going to get this attorney's fees paid by the loser. You put it in the contract. I had somebody call me, guys, listen, get these contracts together, talk to an attorney about it. I had a lady that, another story, I didn't represent her, lady, somebody borrowed $50,000 from her. She does a little half-page contract. I had one question for her. Now she wants to get the money back because they're not paying. I said, you have attorney's fee provision contract. Oh, I don't think so. Okay, now you got a collectability issue, and there's potentially less exposure. Often, the attorney's fee provision is what is a great equalizer. In employment, attorney's fees are granted by law as it pertains to wage and hour issues, as it pertains to discrimination issues, and now as it pertains, and discrimination, I mean FEHA, Federal Fair Employment and Housing Act discrimination, as well as public policy. So until 2 years ago, you couldn't get attorney's fees for public policy. I remember in that very case I'm telling you about, the HR director, I had 14 causes of action. I had public policy, I had wage and hour, and I had discrimination. And they said, you're not going to be able to prove discrimination in this case. And I told them, I said, I don't need to, because I've got public policy violations. Okay, and that case settled early in the litigation for 2 years' salary. Now, that doesn't mean that that's always going to happen. But these are the things that I need in order to intensify or to give your case your best opportunity of success, or what people could call success. It's never guaranteed. A result is never guaranteed, but this is what's really important for you to understand. Be well documented. The keys to evaluating the case are three things. How well documented you are. In other words, if you say that Jim Bo did this and that and the other, and then they pushed me and they did this and that, whatever else, the more that is documented, the more that there's a paper trail, starting off even with your own chronology, the better off you are. When you have a he said, she said situation, nobody's going to admit that they did something to you that's going to lend to their legal liability. That's not going to happen. And here's the other thing, too. The other thing you got to be aware of. In the real world, somebody will tell you on your job that they'll support you because they saw this or that thing happen. But when somebody's trying to keep their job, those things change, too. So that can be very difficult, okay? So how well documented you are, confirming things with emails. When they have you come in and do something, we need to have a discussion about this issue or that issue. Have a witness if you possibly can. Look at the actual rules that the employer has. As a matter of fact, it might not be a bad idea to see whether those rules exist. Have a conversation about them ahead of time, so that you're not looking at whether or not they exist once you get into a situation. So, keys to evaluating the case. How well documented you are. How forthcoming you are. I love going to a deposition and finding out about something from having to do with my client that I've been dealing with for a year for the first time. It's always great. And the other side knew it, but I didn't, because they didn't think it was important to let me know. It's not a good look. Because among other things, here's the problem. If people don't believe you, it doesn't matter whether you're telling the truth or not. Well, I just messed up on this one thing. I forgot this. But people may take that issue, discern a lack of believability from you, a lack of credibility, and now they won't believe you in the real thing that they really need to believe you in. So how forthcoming you are. Let me be the judge of whether or not what you are saying or what you have to say is relevant for purposes of our case. Particularly if you're really going through it at work, you really have a bunch of stuff happening. You might not know what is and what isn't important because, among other things, you've probably compartmentalized. And some of the things that might be a smoking gun for me, that might really help make the case go off, are things that you've minimized because you've had to put them in the back of your mind. So tell me everything. Good news, bad news. You've got attorney-client privilege. Let's talk about this stuff now as opposed to later, because if we talk about it and find out about it later in front of everybody else, it's just not going to look good. Okay? So, keys to evaluating the case, how well documented you are, how forthcoming you are, and here's the other thing, how believable you are. If I am not buying what you're saying, I cannot sell it. And sometimes it's always fun. I mean, I'm sure it's happened with the other attorneys in the room where you just believe a client, you just sit and listen to a client, and you just say to yourself, you know what, I don't believe a word they say. Not a word. Nothing. Nathan. Okay, it's not happening. I don't believe it at all. Okay? And I have that happen where you have a client and you don't believe them, and you know it was a sunny day, but if they come in and they say, you know, it's really sunny today, you walk out with an umbrella because you just don't believe anything. I have that happen sometimes. And here's the other thing. Here's what we do as attorneys. This is what we ought to do. Most of the time, guys, we trust our instincts. And so when our spidey senses tingle, it's a real thing. Every time I've taken a case, despite the tingling of the spidey senses, I have always regretted it. I always find out that if I thought that the client was lying and for purposes of this case wasn't any good, you might have some social redeeming value, but for the purposes of this case, I don't believe a word you're saying. I never did. You made me feel the wrong way at the very beginning. I'm your fourth lawyer. You know what I mean? There are certain indicia, and the other thing I would say to those that would be watching is, you have to be careful about jumping around from lawyer to lawyer too. Because if you jumped around to 2 or 3 lawyers and you come to me and you tell me you got a great case, but the other 3 lawyers didn't think so, or at least not enough, the thing that all the lawyers have in common is you. So you could be the problem, whether you think so or not. Okay, and so be careful about that. So those are the ways that we evaluate a case: how well documented you are, how believable you are, and how forthcoming you are. And as it pertains to these issues, that's why I ask for chronologies. That's why I ask to have discussions with you so I can take those things, do immediate follow-up questions, and I can understand where we are. Sometimes you have a situation where something is morally wrong, but not necessarily legally wrong. Okay? So we're trying to help the best way that we can. And so please take our advice. You take it with a grain and you can go another way if you want to. But be really, really careful and make sure you're bringing a case for the right reasons. Not because I shouldn't be talking to you in your first conversation and you got fired yesterday and you let me know you won $100,000. Well, what does that connect to, like in reality? Okay? Because I need to know a little bit more about what happened, to know whether you have a recovery at all and what level that might end up being. And your damages are continuing. You have the ability to mitigate. You're supposed to mitigate your damages if you get another job tomorrow. The good news is you got another job tomorrow. The bad news is your case is not as worth as much because you don't have the lost earnings. That just is what it is. Okay? So I think that's all I have for now. And what we'll do is I'll go ahead and do the introduction of my next person. Sis is coming up. Kamala Gray at Chung and Ignacio. She's a fantastic family lawyer. She's an excellent church member, a dear friend, family member practically, talking about some things that help. Family law is very emotional, guys. So hopefully she's able to help you take the emotion out of it and do the things that you need to do. Please do not disregard what we are saying because it's really important, okay? And that's what we need to do.